Welcome to Law Potato, Hot Legal Topics with Idaho Values.
Hey everyone, welcome back to an all-new episode of Law Potato, Hot Legal Topics with Idaho Values. I am your host, Mike Leon. Today's episode, I'm joined by Alan Harrison over at Alan Harrison Law, along with Tim Sopalski, who's the firm's Director of Business Development. And we're going to be talking about probate in the state of Idaho. We're going to go over it. What is it? How the process generally works, and what people should realistically expect if probate does become part of settling their estate. Gents, it's good to see you guys as always. Alan, let me start with you on this episode. Explain what probate is. I mean, I'm sure there's a lot of people that maybe don't even know what probate is, and when does it typically become part of settling someone's estate in the state of Idaho?
Yeah, thanks for having us, Mike. The probate is essentially, it's a court process in which if you have a will, you submit that will to the court, and you get a person representative appointed that has authority to gather assets together, pay any debts, and then distribute them. And that can either be an informal court process, or it can be a formal court process that is more governed by the court. But in both of them, you're getting court orders authorizing someone to take action. As far as when it's needed, anytime you have real estate that is owned in an individual's name, you're going to end up having to probate in order to get it out of that person's name. So if we have a couple and the first spouse dies, then for the second spouse, if there's no right of survivorship on the deed, then the surviving spouse, if they want to sell that property, they're going to have to go through probate. There are some exceptions to that in some counties, but that's kind of the general rule. They're going to have to probate in order to get that asset out of their name. And when the second spouse dies, if they've got it out of the first spouse to the surviving spouse, but the surviving spouse keeps it in their name, then when they die, you're going to have to go through probate again in order to transfer those assets. If you don't have real estate and your assets are under $100,000, then you can use what we call a small estate affidavit to be able to transfer those assets. But the other issue is that if you have bank accounts and those bank accounts have beneficiaries listed, then those assets will be distributed according to the listed beneficiaries, and you don't have to go through probate to deal with those assets.
Tim, in the last episode, you mentioned a little bit about probate, how it's an easy process. But when I hear courts, I think, oh, this is not going to be easy at all. So what has surprised clients the most about probate when they encounter it in their realm for the first time?
So for the most part, it's the administration piece. When they actually look at, oh, I thought I could just go ahead and give this to my brother. I didn't think it was that big of a deal. But a will tells you exactly what the wishes are of the person who created it. And when you decide not to follow the will, you have to take legal measurements to ensure that everybody first is in agreement to that. Every beneficiary involved in the estate actually agrees to that. You have to document. You have to literally have record of everything you do. The biggest issue I've seen in estates when individuals are doing it on their own is they leave the bank account for the individual open and they start doing transactions through that account, or they do transactions on their personal checking account. And so they don't go ahead and segregate the accounting into a separate account so that they can easily record what's happening within the estate. That's where most of the mess-ups happen within a probate. Is there's no documentation, no explanation. For example, last night I was working on an estate accounting, and they wrote checks out, and they wrote checks to certain companies, but they didn't put anything in the memo line indicating what that check was for. And so now if I'm on the opposite party side, which we have a little bit of a disagreement, and I say, well, what was that $5,000 for? I have no record of what it was for. And so we're kind of having to go back and figure out, okay, how do we communicate this with the opposite party of what that record is for? So I think the biggest aspect is the actual administration of the estate, because everybody thinks they can just go ahead and distribute everything out according to their own wishes, that the personal representative has all the power to do whatever they want, but they really don't. They have to follow the document. If they deviate from the document, then we have to create what's called a settlement agreement. Some people call it a family agreement. Idaho statute calls it a TEDRA, a Trust and Estate Dispute Resolution Act. And so those things have to be created if we're going to go in a different direction than what the will actually states. And every party has to agree. Every interested party has to agree.
Alan, let me ask you if you can kind of expand out for the audience here, like 30,000-foot overview of how the probate process kind of unfolds in Idaho from the start to the finish. Really 30,000-foot overview for us.
Yeah, so really there's kind of four big parts of it. The first part is getting appointed. You file a petition with the court appoints someone as personal representative. And then within 90 days, they need to file what's called an inventory. And in that inventory, they're just accounting for what all the assets are and what their value is, and then also accounting for what debts there are and what's owed. And that's the second part, the inventory. The third part is the administration that Tim just talked about, just documenting everything that they do as the personal representative, what assets there are, what debts they pay, and then getting a final value. And then they either get everyone to agree to that. And if they get everyone to agree, you do that estate settlement agreement or that TEDRA agreement that Tim just talked about. And that settles the matter. And you submit that to the court. And then that brings in the last piece is the closeout. That if everyone agrees, you submit that agreement to the court, the personal representative take actions to carry out what's said in that, and then they submit a final document to the court saying, hey, we've carried everything out. If people can't agree, then in the fourth phase, in that closeout phase, you're actually asking the court for permission to say, hey, acknowledge these are all the assets, these are the expenses, and this is how things should be distributed. Those documents are submitted to the court, given to all the heirs so that they have an opportunity to contest or disagree. And then if they don't, then the court will issue an order consistent with what the personal representative asked. If they do contest it, then we have a hearing and the court looks at all the evidence. And at the end of the day, the court issues an order and then the personal representative carries that order out. And once they've carried it out, once again, they give proof to the court that they've carried it out, and then they're discharged as the personal representative. So those are the four big areas: getting appointed, getting an inventory of what all the assets are, administering the estate, and then closing it out either with agreement of everyone or with a court order.
Yeah. Great stuff and insights there into the process. Tim, in the previous episode, you gave us a little bit about your background and why you got into this, because there was heavy emphasis on the planning part, right? Can you kind of explain to folks out there why organizing all of this, the advanced planning, how it will play in making the probate process a lot smoother for them, for the folks out there listening when they're handling the estate?
I think a big part of, at least here in Idaho and in the older generation that we're seeing going through this process, the first spouse typically, I'm going to say it, whether it's unpopular or not, the husband is typically the first one to go. Okay. The husband was the one that was handling all the finances in this generation. And so therefore the spouse is left not knowing anything about the financial side. And so typically you have a widow coming into the office and saying, I know nothing. I don't know how to pay this. I don't know how to handle the utilities. And so that's heartbreaking because you want to assist and help them. And the challenge is we don't know either, right? We don't know what he had going on. And so by having a plan ahead of time and acknowledging that if one spouse passes and the second spouse is going to take over the day-to-day operations of the family and of the home, are they prepared to do that? Do they have the ability to go in and handle those records? The other side of it is if both spouses pass away, can the kids step up and know exactly where all their assets are? Unfortunately, with that generation, sometimes you have cash under the mattress. That's a real thing. You'll be amazed where I found cash in people's houses. You have investment accounts all over the place, whether they're at, different brokerage firms or different banks. You'll have CDs. You'll have all these different accounts that, unless it's organized and planned out, your personal representative has no clue where they are. And so a big portion of their time is spent trying to track it down, pulling the tax records for the last 3 years is what I typically recommend. Going through and seeing which organizations provided a 1099, that will tell you where they're at as far as their investments are concerned. Looking to see what accounts they have set up, going to different banks and trying to find out where they're at. But there's a big piece of that going through the mail, because most likely they have mail statements. But if they switch to online, you also have issues there. So I think there's a big conception of, if you plan ahead and at least give them some kind of breadcrumbs of where to go, they can figure it out from there. But if you don't do any planning, then they're just throwing darts at a dartboard and hoping it lands somewhere.
Right. Well, Alan, earlier in the episode, you had mentioned about that magic number of 100,000 no assets and what people have to do. But what happens and how does probate differ when the estate actually includes more assets, more property, business interest, accounts with more money without naming beneficiaries? Like, how does that complicate things?
Yeah. So with real estate, if real estate's in your individual name, then you're going to have to probate. If you have business interests and there's been no planning, if it's just a husband and wife business, you still have to sell that business, gather all the assets and distribute them. If you have partners in that business and there's no clear agreement with regards to what's going to happen with your interest when you pass away, that could put a real financial hardship on the remaining owners of that business. If you have a family business, in Idaho, we have farms. And so if you're dealing with a farm or another family business, and if there's just one, maybe two siblings that are working in the business, and that's the bulk of the assets of the estate, then you've got to ask, is that bulk big asset going to go to these two children or one or two children that are actually working in the business? Or is the business going to be sold? Or is there going to be some life insurance that would equally compensate the other heirs? Or is their assets sufficient that the other heirs can take other assets? And so those are all things that anytime you have business interests, it makes things just a bit more complicated. And then I think you also asked with accounts without named beneficiaries. Once again, if you have an account without a named beneficiary, then that will just come into the estate and it'll be distributed how your will or your trust says. One thing to be aware of, we deal a lot with families with special needs children. And if a child is going to inherit over $2,000, that's going to disqualify them for the government benefits. And so we really talk with families and make sure that they have not listed a special needs child as a direct beneficiary. Also, we talk with them about making sure if the grandparents or aunts or uncles, if they want to leave money for this special needs child, that they don't leave it in their name, that they put it into a supplemental needs trust where they can inherit that money, but it doesn't disqualify them for all those from benefits. And so we go through that with clients. We just look at what all their assets are. Like Tim said, in my mind, that's one of the biggest things about estate planning is just it forces you to identify what are your assets. And we just try and get a snapshot for right now and then go through and talk with them about how they want those to be distributed and what beneficiaries they do or don't have, and whether we're going to use a will or a trust to distribute those.
Yeah. Well, gents, as we put a bow on this episode, I love hearing the client examples part of this. So, Tim, I'm going to start with you, and Alan, you can kind of piggyback. Can you guys share an example that really illustrates how the preparation side, or even the lack of the preparation side, changed the experience for the people that are responsible for carrying out the estate? Tim, I'll start with you.
Yeah, I think I've seen them both ways, right? I've seen ones that were, in my opinion, maybe overly planned, and you go through those and you see that, okay, you've literally thought of every situation, even though you can't think of everything, these people did. And you look through it, and the person that's serving as the personal representative is able to step in and handle everything appropriately. It's a smooth transition. The family gets along. Everything goes great. It's those that there's no planning that you see it all kind of creates that chaos that we talked about, right, previously. So it comes back to without a plan. I've got one right now that they had They had no plan. And when they looked at how do we get from point A to point B, no one knew what they were doing. So they ended up spending more money because they had to actually hire us as attorneys. So Alan is the attorney, myself as a specialist, to go through and try to figure out what was going on. And so it's the old adage, pay me now or pay me later. And now it's going to be more cost effective than later, right? And so really it comes down to, do you want to set your family up for success or not? And I've seen some that are kind of in the middle. They do some planning, but they don't follow through with it. I've got one right now that you go back to the LLCs, the different operating agreements. They have operating agreements that do not name their trust as the owner of the business. And therefore now they're having to go through probate. And the whole intent of creating and planning the trust was to prevent probate. But now we're having to go through probate in order to take care of their interest within that business.
Yeah. And Alan, for you as we close?
Yeah, just kind of piggybacking off that business. I had one client that he was in a family farm business, and his dad and uncle weren't real excited about talking about succession planning. But I just encourage the client that it's going to come to a point when you've been the one that has put the most energy into this, of your brothers, of your cousins. And so he was able to just continue, and it took several years of talking with his father until they were able to work out a buyout plan that made sense for everyone. And that provided clarity to the son that had been working in there a long time as to how this would go forward, or if you need to look at something else if it wasn't going to go forward. And just the other day, I talked with another guy, happened to be just out in the community, and he has a partner, and they have not planned. They've got a business, they've been running it, and his wife keeps bugging him and saying, "Hey, if something happens to you, I don't want to be left trying to deal with this other partner." And so in that case, they don't have a plan yet. And so I've been in discussions with him about what kind of a plan do they want? Do they want to sell the business if something happens to him, or are they going to get insurance to pay out? Just how, or if they don't do insurance, are they going to get that the surviving partner is going to pay to the surviving spouse a certain a monthly amount? But and so there are very different options. It's just a matter of planning and making a choice so that it provides clarity to those that come behind.
You got to do it, folks. Don't put it off for another day. Gents, thank you guys for the time, the insights, explaining all this to the audience as always. I appreciate it, guys.
Thank you, Mike.
That wraps up today's episode of Law Potato, Hot Legal Topics with Idaho Values. You heard what both of these guys said. And if you want to learn more about not only the probate process, but estate planning or planning ahead in the state of Idaho, you can find Alan and Tim over at aharrisonlaw.com. Go visit them today. Schedule that consultation. Do me one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.